78-year-old, which is amazing. Even though this court only 2 terms ago announced a ruling that reversed these other things, Judge Newman resisted her campaign of intimidation. And let's take a look at Judge Kimberly Moore. Who is this judge? Judge Kimberly Moore. And by the way, this lady was appointed by Reagan. And Kimberly Moore, let's take a look at her. This is a Bush appointee. She's age 57. She went to Georgetown. This is the judge. It's judge versus judge today on this little Fun Friday excursion. It says here, this is a George Bush judge. Right here, Kimberly Moore, U.S. Circuit Judge for the Federal Circuit. George Bush appointed her. And interesting. Oh, this is curious. Her husband is a law partner at Latham and Watkins, which is one of those hack law firms that represents Democrats. So Judge Pauline Newman says that all these laws are invalid, and here are some of the proceedings that have occurred. On December 15, 2022, Judge Newman authored one of her excellent dissents in a decision. This court later adopted much of her reasoning when it reversed. The Supreme Court accepted her conclusion and overrode Kimberly. Some 2 months after Judge Newman wrote that dissent, Chief Moore removed her from normal panel assignments. Dang, that looks like retaliation. Then the next month, the Judicial Council ordered, yep, she's too old. Sorry, you can't hear any more cases. And the order relied on personal knowledge. Although none of them had initiated a complaint, Judge Moore, Kimberly, claimed that other, quote, judges and staff had brought concerns to her about something going on. The order also referred to the statements that Judge Newman had made during deliberations when no one other than the other judges were in the room, and saying people are expressing her concerns. Because the investigation was initiated by the chief judge and based on accusations leveled at her, Judge Newman asked the chief judge and others to transfer the investigation to a different circuit, saying, I know you hate me, so you can't investigate me. Have other people do it. Before the investigation even began, the chief judge removed her from the normal panel assignments. That was improper. The Disability Act doesn't allow you to do that. When Judge Newman emailed the chief judge and asked her to reconsider her exclusion, Moore rebuked the judge and replied to the email via an email list named all judges, so like puts her on blast to the entire panel. Because that list included everybody, the use of the email was also misconduct. The special committee ordered her to submit to neurological and neurophysiological testing by doctors chosen by the committee. The committee also ordered her to provide her hospital records, medical, psychiatric, psychological, and other health professional records. Newman submitted these expert reports. She did hours of testing, and her cognitive abilities are perfectly intact. But the committee rejected those expert reports and declared her guilty of misconduct for refusing to cooperate. It recommended that Judge Newman not be permitted to hear any case, period, and she was removed. Then on September 6, 2024, 14 days before the expiration of the suspension order, they suspended her again for another year. Now, the upshot here is that she has been barred from any functions since 2023, the date which she issued her last opinion that embarrassed all the other judges. And so we've had a bunch of proceedings, lots of details on this. Let's fast forward and see what they argue is the basis for accepting this petition. They say the court should accept this. It's judicial lifetime tenure, and she's fine. She's like spry 78-year-old judge, no problem. This court has also construed statutes that prohibit judicial review. Some of those can be unconstitutional, and so you should do that here. And Judge Newman has raised a host of constitutional challenges, and you should hear this claim. Supreme Court of the United States. Very technical decision here, or argument here. At the very least, grant the petition, vacate the underlying decision, and stop saying you can strip jurisdiction to hear these claims. The courts of appeals should be able to do that. And let's continue on. The chief judge is using this act because she doesn't want her to serve on the panel. These are heavy-handed tactics. You can't have one judge just say, I don't like you and you're too old, so get out of here. Other judges are watching what's happening, and they're wondering if a similar fate will befall them. Well, some judges actually should be removed under these reasons. Like, for example, the one judge we're thinking of is Royce C. Lambert. I think, falls asleep and drools on himself on the bench. And I've been in front of judges, by the way, who are like just like comatose on the bench. They're like, judge, like somebody's like, the clerk's like poking them with a stick. All this needs to be nipped in the bud before any more damage is done to the constitutional limitations on judicial appointments. Her colleagues have thus far succeeded in silencing her. She was a dissenting voice, and her effective removal from the bench has had a dramatic effect on the number of dissents issued here. One recent study concluded that since she was removed, the rate of dissent in the federal circuit has dropped from 12% to 4%. Losing out on her dissent is not good. And attacks on the independence of the judiciary are coming from both the left and the right. And so for these reasons, we need you, Supreme Court, to step in, issue a strong statement in support of judicial independence, respectfully submitted by the new Civil Liberties Alliance up to the Supreme Court of the United States. And of course, we'll see what they do about it. The case has not been docketed yet. Reagan nominated Newman to the newly created federal circuit in '84. It hears appeals on specialty topics, and she's known as the Great Dissenter. But she's been on the sideline for a long period of time, and her colleagues all booted her off. So this is going to be an interesting one to watch. A little bit different there. But shout out to our senior citizens. We appreciate what they bring, and hopefully Supreme Court can settle this for us once and for all and determine whether she shall remain in her judicial position. Sounds like she wants to be there until the end. So we'll see what happens with this one. Thanks for joining us as we do. All right, so friends, a little bit of a different story there today, but a little curious there. Now, the other thing we were keeping our eye on this morning, which just went live, is this one right now. So we've got, let's hang out here for a little bit. I've got an ultrasound, so I can't hang out too long on this one, but let's check in what's happening here. Let me rewind this because it looks like this just started like a minute ago. So it's not going to be perfectly live, but pretty dang close. All right, so here we go. Out in Georgia, we've got Nathan Wade.
I want to recognize Mr. Nathan Wade has joined us. Thank you for being here, Mr. Wade. You're joined by your counsel, Mr. Evans. And then, Mr. Barnes, are you serving as counsel? Are you hanging out? What's your... Would Mr. Wade say that you're serving as co-counsel as well, or is that... So I do want to thank you for being here today. A couple of things before we get started, and then we'll swear. I don't know if you've had a chance to view any of the other proceedings. We've been charged by a Senate resolution essentially to look into really a couple things now, but as it relates to you, the Trump election interference case. We've taken testimony from a number of folks actually, not just folks you work directly with on the case, but people, legal experts from around the state. And that's going to be the scope of what we're going to ask you about today. And the goal for us is to see if there's any steps that we need to take to reinsure public confidence in the justice system. Chairman Cowsert brought, what did you write, Chairman, 5 separate pieces of legislation so far? 5 pieces of legislation. I think you passed 3 of them out of the Senate. So that's really the goal of what we're trying to do here today. To the extent that you want to discuss anything with your counsel, obviously you're more than welcome to do that. I do have a mic control here, just like we did this morning for Mr. DeSantis. I will, as I see you two talking privately, I'll just mute the mic so nothing gets picked up by the media. And so if you hear me say you're muted, that's what I mean, and I'll unmute. If you want to ask me to do that, I'd be happy to do that. But I'll try to just kind of toggle that as I see you guys discussing things privately. I'll open up with a line of questioning, maybe take a break depending on how long we go. Leader Jones has the option to do so as well. And then Chairman Cowsert had asked some questions previously, and obviously that would be at his discretion as well. Did you have any questions or anything before we get started?
But I do have an opening statement I'd like to read into the record.
Sure.
Good afternoon. My name is Nathan J. Wade. I am here on my own volition after accepting service of a subpoena from this committee. I'm a lawyer in good standing with the State Bar of Georgia. I served as a special assistant district attorney for the Office of the District Attorney of Fulton County beginning in 2021. Before accepting that appointment, I worked as a prosecutor, ran a private law firm, and served as a municipal court judge for over a decade. For my appointment as special prosecutor, I swore an oath to follow the law. I took the oath with solemn pride and responsibility. I did not accept the position to financially reward or benefit anyone, namely District Attorney Vonnie Willis. My team and I investigated the state of Georgia versus Trump et al. For approximately 2 years or more. The investigation was not politically motivated or influenced. Bullshit. Rather, it was an independent investigation based on facts, interviews, evidence, and the rule of law. I was not directed, ordered, asked, coerced, pressured, or importuned to bring any charges in that case. We simply went wherever the evidence led us. No one at the White House Counsel's Office, the Department of Justice, or the January 6th Committee directed, ordered, asked, coerced, or importuned or pressured me to do anything in that case.
Yeah, but they worked with you.
I did not violate a single rule of professional responsibility in the Trump case. I did nothing to compromise the integrity of that investigation. After a thorough and independent investigation, we presented our evidence to a special purpose grand jury. In August of 2023, the grand jury returned indictments against 19 people, 4 of which entered pleas of guilty, and rightfully so. In January of 2024, a co-defendant moved to disqualify D.A. Willis and myself from that case. The court held a hearing during which I testified, was cross-examined by each defendant's attorney, and the link to that public testimony will be made available by counsel if anyone needs it. On March the 15th of 2024, the court denied the motion to disqualify. In that order, the court allowed the Trump case to continue only if D.A. Willis's office resigned or if I resigned. Later that day, I voluntarily resigned. Since then, I've had minimum contact with the Fulton County District Attorney's Office.
What about Fannie?
I've had no access to documents or evidence kept there. Based on your assertions to my counsel, the committee agreed to limit my testimony to an hour. The committee also agreed not to ask about any personal relationships or any pending or current investigations and prosecutions.
What?
I request that we honor that agreement, and my counsel will object if we do not.
Don't ask me about Fannie.
Please remember that my knowledge about many topics is limited because I have not worked or been contracted at the District Attorney's Office of Fulton County since I resigned in March of 2024. Also, many of the events happened years ago, so I may not remember specifics. Further,
not that long ago, we remember.
Confidentiality agreements with the Fulton County, grand jury secrecy rules, and Georgia Rules of Professional Conduct 1.6a, which requires me to maintain in confidence all information gained in professional relationships.
You know how this is going to go.
I'm here to cooperate. I will answer questions to the best of my ability, but within the confines of professional and ethical responsibilities. In that light, please allow me to further read into the record this notice and general reminder that I've received from the Fulton County District Attorney's Office.
From my girlfriend.
My position.
From my lover.
It says, Dear Mr. Wade, I write to you in my official capacity as District Attorney for the Atlanta Judicial Circuit and on behalf of my office regarding a recent subpoena that you received from Senator Bill Cowsert and Lieutenant Governor Burt Jones requesting your testimony before the Georgia Senate Special Committee on Investigations related to your former contract or employment as a special prosecutor with the Fulton County District Attorney's Office. The subpoena does not provide any indications of what matters or information your testimony is expected to involve, but given the focus of your work as special prosecutor, I expect that your testimony will relate somehow to our office's pursuit of accountability for the unlawful attempts to overturn the 2020 presidential election in the state of Georgia.
Fannie just scolded him right
To
there.
make clear my official position as district attorney, I write to remind you of your continuing obligation not to disclose any confidential information related to this office's criminal investigations. including information that is protected from disclosure by grand jury secrecy rules or applicable legal privileges held by this office. To that end, this letter serves as formal notice that the Fulton County District Attorney's Office is asserting all applicable legal protections and privileges over information you have obtained as a contractor of this office. This includes knowledge, evidence, confidential attorney communications, discussions of legal theories and analysis, editorial days and deliberations,
Just inviting each other
of the sources and techniques.
Jeez, Pete. I accidentally put it for inside. I gotta remember next time I order, I gotta switch it over. Oh man, that cut off. Damn it. Sorry, guys.
A similar letter, which I have attached. This letter serves as the same purpose, and the office asserts the same protections and privileges. In their absent attempts to serve the desires of a few individuals rather than the rights of millions of Georgians, and to discredit the good work of our office to defend the rule of law, members of the committee have recently subpoenaed me as well. My objections to these latest efforts remain the same. I am concerned that questions and confidentiality interests. These include preservations of the secrecy of grand jury privileges,
Jesus.
federal court, and the courts of the state of Georgia. Attempts by the committee to solicit information from you about evidence in the election interference case would run afoul of these fundamental principles. Additionally, questions about the substance of your work Each case would also seek information that is
That's
protected
a big
by
fanny
the
letter
delivery
right there.
process privilege, attorney-client privilege, and work product privilege, among others. As Chief Justice John Roberts has observed, it has long been understood that recipients of legislative subpoenas retain common law and constitutional privileges with regard to such information. The site is Trump v. Measures USA. It is the responsibility of the FCDA and its employees to protect secret grand jury information or information that is privileged, confidential, or sensitive. As former appointed special prosecutor for the office, this is your responsibility as well. Any protected information would belong to the office, not to you personally, and accordingly, you should refer the committee to this
Don't
office
you say a
for
word,
any such
says
information.
Fanny.
As you are undoubtedly aware, the sharing of non-public privileged information violates Georgia professional ethics rules, including special rules applicable to prosecutors. Such disclosure can prejudice defendants, victims, or witnesses, or affect the overall integrity of the proceedings.
It's been dismissed.
I know that you intend to comply in good faith with all proper legal requests related to your work with the office. Although I'm sorry that you are forced to deal with the ongoing efforts by others to attack the legitimacy of your work, I thank you for your steadfast compliance with the law
And I love
for
you.
your adherence to the claims of privilege laid out in this letter.
And I love you. I'll see you.
I believe that the efforts of Senator Coward and Lieutenant Governor Jones and the never-ending investigations into the FCDA by them and by others, such as Congressman Jordan, are a part of a transparent and shameful campaign to use the force of government to harass, silence, and punish those who have been brave enough to stand up to Donald Trump. No true public servant deserves
Whoa,
this
look at
kind
that
of
truck.
harassment.
Man.
He's writing this.
As I have previously indicated, I am grateful for your work as a special prosecutor and your commitment to the highest ideals of American democracy. Yours in service, Bonnie T. Willis, District Attorney, Atlanta
Fanny.
Judicial Circuit.
Her name's Fanny.
Copies of this
Nathan,
letter
you know better than anybody what that
counsel
means.
as well.
Thank you, Mr. Wayne.
I stand ready to respond.
I'd like to go ahead and swear you in if that's okay. You could raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. I do want to clarify, and Mr. Miller, maybe you can weigh in on this. I did not believe we had agreed to a time frame for this testimony. I certainly don't want to be here longer than we need to be, but I do want to just make sure that we're all on the same page.
1 hour?
Start with
Like nothing. You just burned out 10 minutes.
My knowledge, I'm happy to discuss our first break, but just for context, our earlier witness started at about 10:30 and we were finished before noon. So I don't.
We go over a little bit, that's fine. I talked to Josh Belfonte about restricting it to an hour. So
okay.
Yeah, that was my understanding of all this.
I certainly think that I'll get through my stuff with under an hour, I hope. And then we'll see whether we can break and see how much time we think we have left. Mr. Wade, thank you for that opening statement. It kind of gets to a little bit of your background, so I don't want to belabor that too much. I think some of that's also just kind of been out there in the news cycle over the last couple of years. So given our time restraints, I don't want to spend a ton of time on that. I do want to just get into a couple of things that the committee's talked about over the past couple of months. But first and foremost, if you could walk me through your process of being hired. I understand that there was some taint work that was done, I think, by your firm and maybe a firm that you have some partners in, and then that kind of transitioned into, part of the transition team. If you could just lay that out for us, and if you can get us all the way through to being appointed as special assistant district attorney, that'd kind of be as far as we want to go with that.
Yeah, well,
sir, you outlined two separate processes. I had nothing to do with doing taint work with the Fulton County District Attorney's Office. Those contracts were held by two other lawyers. Nothing to do with myself.
Okay.
My appointment to becoming a special prosecutor dealt with my familiarity in terms of being a municipal judge and Ms. Willis being a municipal judge at the same time. We developed a sort of a mentor-mentee relationship.
Yeah, I bet you
over
did.
the course of time.
Yes, you did. That's true.
Great. Walk me through the work that you did on the transition team. I think that you were part of a transition team, as I understand from Ms. Willis's testimony, between
That's nuts,
her
man.
election and her swearing in.
During spring break season.
Correct the record for me.
So briefly, I was a part of the transition team. I didn't officially participate in all the work that transition team performed. I was continuously a part of.
Man, look at this shit blowing all over the place. Oh, wow.
Advisory committee, if you will.
Okay, that was just foam, but still.
And there was, at some point in time, there was a search committee that was formed. Mr. DeSantis mentioned that this morning. DA Willis discussed that as well. There's a search committee that's formed essentially to look into someone to lead the Trump election interference case. Is that correct?
Yes, sir.
And you were part of that transition team. Is that correct? Sorry, you were part of that search committee.
I was.
Is that correct?
I was.
Who else was it? Was that an official committee that had named members, or was it more of an ad hoc committee?
No, it wasn't. I don't really recall the specifics of how it was put together. But I do recall taking part in doing the work. I couldn't tell you who else was all involved, but I know that she was taking.
With all our dogs and cats, it's hard for us to travel unless we get a house sitter.
Do you remember approximately when that work began?
Surely can't afford to kennel them for that long.
I don't. It was after she had won the election, obviously.
Okay. The meetings that you had that you were a part of, do you remember anybody else who was a part of those meetings besides the district attorney?
I don't recall if I seem to recall that all the meetings had different members, so there was never a set group of people that met in that regard. And so because of that, I'm having a difficult time recalling.
Do you remember any either formal or even casual interviews for candidates that would be a potential special assistant district attorney?
I do.
Can you tell me more about that, please?
Well,
look at that.
Governor Barnes.
Traffic back. Oh, they're backing.
Be able to answer that
can't do that.
a lot better than I
backing off the on-ramp.
Individuals who was asked, I wouldn't call it an interview, asked to step into the role.
And he turned that down, as I understand from previous case load. He had some current concerns about the publicity and security concerns that may come along with that case. Do you remember anyone else that the committee either talked to via a formal interview or informally?
Yeah, I recall. I recall Attorney Gabe Banks being asked to step into the role.
He officially offered a role, and he turned it down as well.
Yes.
Okay. Was there anyone else you recall that you talked to that turned down the role or was never offered the role?
I don't understand the question.
Was there anyone else that the committee approached about the role?
There were other people, other candidates. I do recall DA Willis being very deliberate and careful about whom she selected for the role. There were lots of people who were sort of applying or wanting to do it because they had political agendas one way or the other, and she was astute enough to sniff those things out immediately and disqualify or do away with those particular candidates. But specific people, I don't recall.
Okay. Do you remember approximately when the focus turned to you as a possible candidate?
I don't remember in terms of time, but I can recall because DA Willis either was not satisfied with those who were applying to do it, or those who approached to do it had said no. he asked me to do it. Initially, I said no. I had no desire. Now, had I, in hindsight, I probably would have gone and had another conversation with Governor Barnes to get some specifics about his concerns, as opposed to going through the deliberative process alone. But I did, and ultimately I accepted the position.
I'm curious why you didn't have a desire. It's a high-profile case. You're an accomplished attorney, dealing various work, both as a judge and as a lawyer. It seems like something that.
What is going on here? Why are the Easy Pass ones full too?
Yeah, I do. I rather enjoyed serving as a municipal court judge. One reason would be I would have to step aside, take a leave of absence from that position. The other reason was my firm at that time was doing very well, and I didn't want to step away from that work. The pay obviously was not very good. I don't think anybody can debate that point.
I think the ticket machine is not working or something.
There, my man.
And the subject matter, candidly, just didn't get my attention.
What caused you to change your mind?
Fanny seduced him.
After having more discussions with D.A. Willis and having more discussions with those that I look to for advice and counsel, and I have a love for different areas of law,
and Fanny,
and this was that for me, so I did it.
Okay. Do you remember if you remember even the month, that'd be helpful, the month at which you officially started in that role?
I don't.
Okay. You served in that role up until 2024. Is that correct?
March.
And it would be best described, I believe that the DA described this way, so you were essentially the lead of the team that was working on the election interference case.
Yes, sir.
Okay. I want to ask a couple of questions that have come up, and this one that you've seen it discussed, I'm sure, as it relates to the billing. There's been some discussion of this block billing, and this is just an example. This is one of the invoices that you submitted.
24 hours, no key breaks.
I believe that you testified that on occasion you would submit invoices and you would receive questions back from the DA's office. There'd be some adjustments to the invoices. Is that correct?
So I don't know if the questions would come from the district attorney's office or if they would come from the accounting department within Fulton County. But I would get the question and I would respond to it.
Do you remember was the nature of those questions relative to essentially the tabulation of the invoice, which would make sense for it to come to accounting, or was it more so around your description of work that you have listed on the invoices?
No, I don't recall the nature of the questions.
Okay.
35 G's right there.
It was stated under testimony of the district attorney that was her opinion, or at least her position.
Meetings, 8 hours.
That oftentimes you work more hours than you bill. Would you agree with that assertion?
I would agree with that.
Oh yeah. I'll do some squares.
Help me understand kind of how the process worked, given that. And you
take it over now that I'm here.
Some sort, I believe, in your contract.
Sorry, homie.
Maximum.
Trying to be careful. Oh, his tarp got ripped off. Ew.
Dollar amount each.
That wind.
Obviously, couldn't bill more than that. As it relates to these invoices for 8 hours, would you say that the majority of those were 8 hours? Would you say that some large percentage of them where you went over on time and only billed for 8 hours? I think that you would agree.
Yeah, I worked 10.
That's unusual to see kind of that rounded billing. We've looked at this committee, other billing from people again across the board on the same case. And this is just one example of one of Ms. Cross's invoices, and they're down to looks like the 10th of the hour. So walk me through, essentially, help me understand the block billing. And then I want to get a further understanding, if you could, as to how many days you think you went over. I see on the right-hand side there, you did bill for, you kind of have multiple days covered, 12 hours across 2 days, that kind of a thing. So I just want to understand the bill.
Man, it's fucking warm here.
If you need a more specific question, I'd be happy to ask it more specifically. But I just like to understand your perspective as you've heard the commentary around the billing practices here.
Yeah, so it's simple. If you take a look at the bottom of this invoice, this invoice specifically says submitted the 31st day of August 2022. Look right above that line. It says, due to billing restrictions, this invoice has been significantly truncated, which means that I was not allowed to bill over X amount of hours. That does not mean that I can complete the task. As a matter of fact, I can tell you for a fact I could not complete any task in the amount of time that I was allowed to bill. So the way that you see those bills, each and every one of those bills is the truncated.
I'll go back to this one just because it's probably easier for us all to read.
You worked way more than he billed.
What do you mean by that when you say that each and every one of them is truncated? Do you mean essentially the total
Water, or is
truncated,
this
or do you mean each entry is truncated?
dust hitting me?
Each so the first entry there, you see 4.3. Now that's in 2023.
That's gotta be
I
dust.
don't
Jesus.
remember what that was even about, candidly. But I can tell you, I can tell you.
That's why you have more
if I
details in your
billed 8
records.
hours, it probably took me 16 to do it.
Okay, so the fraudulent really reports.
So on 4/13, you're working more than 8 hours that day. 4/3, 4/4. Then the
Get off
3
the
days
kind of
plan.
truck.
So sorry.
Toss of dust.
If you look at the top portion of that billing invoice where it says description in the blue, right next to the word description is date completed. So the dates that you're seeing are the dates that the task was completed. That is not the date that the task begun. So if you see 8 hours and there you see 8 hours bill, it was completed on 4/3.
Okay, so you
I
had a
could
meeting.
start that task 2 days prior.
So that first one, there's a meeting with team.
Yeah, look at the description.
So obviously, a meeting with the team is a day. I would assume. Are you saying that you're having multiple days of?
Listen,
I know you don't know the specific. I'm just saying. Let's just pick that one out as an example.
that's great. That's a great example. I will tell you this: that team and I probably met in one day, probably 6 times in one day, and that's a small frame. We were constantly meeting because we had a lot of evidence and a lot of work to do.
No, you backfilled. You needed to reach 35,000, and you made it up going back.
Because for the most part, I believe you testified to this. More or less, you were going into an office. You weren't working from a Cobb County Marietta office. You were working out of some office. I know you won't disclose the location, but there was an office where you were going to work with the rest of the team was working out of.
Absolutely.
Okay. Great. One of the things that the committee's discussed is the accounting here indicates that not all of your bills, but some of your bills are paid out of county forfeiture funds. We've taken testimony as a committee around the use of forfeiture funds. Do you have any knowledge that you were being paid out of forfeiture funds?
I don't even know what forfeiture funds are. So.
Okay. So forfeiture funds there's a split, as I understand it, where essentially criminals have their property seized, that property is sold, that a percentage of that money goes to the sheriff's office. The bulk, actually, of that money goes to a sheriff's office. 10%, Mr. Chairman, flows down to the DA's office. It was, there's some examples here where you're paid out of, out of Fund 100, which is the general fund, and then some that was the forfeiture funds. I didn't know if you were part of any conversation around different sources of funds, or if you were just sending an invoice, the check came in, whatever it came in. Obviously, you're not reviewing that check probably to see a fund number on it.
So, first and foremost, I have no knowledge of what this document is. I've never seen it. Secondly, once I submit an invoice, if there's not a question about the invoice, I expect payment. Now, albeit when I received the payment, it was most of the time 2 or 3 months later. So I have no clue where the funds came from.
Do you recall one thing that we received testimony on from somebody who works with PAC, I believe, was that one of the limitations that he referenced as it relates to forfeiture funds is you're not supposed to be able to pay anyone more than the prevailing rate of a county employee. And that's about $75 or $80 an hour in that ballpark for the district attorney's office hourly rate for a county employee. Obviously, your contractor rate was more than that. Was there any conversation that you recall about a need to adjust your rate because you were being paid out of forfeiture funds?
Never.
Okay.
Now, I have a need to adjust my rate. Obviously, I'd like to be paid at my normal hourly rate, not the pennies that I was paid. But
Pennies.
Okay. You testified, I believe, to Mr. Jordan's committee. Is that correct?
in
Congressman Jordan's.
yes,
And there was some testimony there relative to the start of the date of the search committee. And we've kind of gone around on this a couple of times, but I do just want to understand it because I think that your testimony seems to indicate that those conversations were taking place.
Sorry, what are we looking at here?
This is a
Transcript in the depot
section of the, I guess it was a deposition for Mr. Jordan's committee. Back in 2024, I believe was the date of that. And really what I wanted to get to was here. You want me to pull up the full document? I can pull the full document. That's easier. I just pulled a screenshot here. But you were asked, and so the search committee, you said that began when DA Willis took office on January 1st, 2021. Is that correct? Yes. And there was outreach to you to be part of the search committee prior to January 1, 2021. Absolutely. When did that start? Sometime after the election, but prior to her taking office. Now, you told us today that it was sometime after the election. So that's consistent. Is it your recollection that it was also prior to her taking office at the search committee?
So I'm going to need some context here because, and I don't know if anyone has shared this with you, she had actually formed several search committees. There were committees to fill her office staff. Are you referring to that?
No, I'll pull up the context for you here. It's going to be a little bit harder for me to do it, but let me just try to get this over on the screen.
Delay. Let's burn through that hour that no one agreed
That's
to.
all it up. What is that document? I don't recognize it. What's the full context? Burn time.
This top part actually is you talking about the interesting legal issues in the case and kind of what we just covered. And so the search committee, you said that DA, this is what I just read, you said DA Willis took office on January 1st. Is that correct? Yes. And was there outreach to you to be part of the search committee prior to January 1st? Let's go up to see what search committee we're talking about. So January 1st, I was part of the search committee for the newly elected district attorney, and we were tasked with trying to identify someone who would serve as lead counsel on the election interference case. The goal or trick was to make certain that the individual selected was one who had no axe to grind, if you will. You just said the same thing here. 3 to 5 candidates said the same thing here. Reference Mr. Barb, so we can cover all that. So we're in the context here of the search committee for someone to lead the special, the Trump election interference case. And so you talk about people turning it down. Mr. Barnes turns it down. Reference same thing you just did. You didn't get enough credence to his warnings. And so the search committee that you said began when DA Willis took office on January 1st. Is that correct? Yes. And there was outreach to you to be part of the search committee prior to January 1st, 2021. Absolutely. But when did it start? Sometime after the election, but prior to her taking office. Okay, so between the election, you referred to the November 2020 election. Is that correct? Yes, ma'am. So when you had the conversation with individuals, you said on multiple occasions, you said no and turned their positions down. Who were those conversations with? And so I want to go back up to this, and the question I want to get back to is you testified today that it was sometime after the election that you were part of the search committee for the election interference case, you mentioned here as well that was prior to her taking office. Is that still what your recollection is?
So, and I think she's answered this for you. You can't form a committee before an actual act has occurred. Respectfully, I just don't think that what you're driving at is possible.
Which act did occur? Because the indictment states that the conspiracy started in November of 2020. The Trump electors met at the Capitol in December of 2020, which that was in a time period between the election and her taking office on January 1st. Obviously, the electors being here was news. I think most people knew that had happened. Certainly was controversial. So the phone call that happened on January 2nd obviously happened after she was sworn in, but the actual reason that a lot of these people were indicted did indeed happen before she took office.
Are you telling me that, or what?
Well, I want to establish those facts. I would ask if you would disagree with any of those facts, and then given that, because your assertion essentially was that nothing had happened until after she was sworn in, and I would actually respectfully say that according to the indictment, it was actually the assertion of the indictment that things did begin before she was sworn in.
Okay.
So did the conversation happen relative to a search committee before she took office?
I don't recall.
You don't? I'm sorry.
I don't recall.
Don't recall. Okay. I'll try to get back to this view here. Thanks for indulging me on that.
Yes.
Yeah, were they already in cahoots before she officially even took office?
Yeah, I think Michigan is playing in the Big Ten tournament right now. They're playing Ohio State. They're up by a few. 7 minutes left. Man, this wind is blowing.
Slide here. This slide's a couple of pages later in Jordan testimony. Could you end the conversations with anyone besides D.A. Willis regarding the special prosecutor role and Governor Barnes, I'll say, referencing what we've talked about?
You ever heard of a low water advisory?
There's a name that we don't know. He's the individual.
When the winds are blowing like this, the west side of Lake Erie loses about 3 or 4 feet because it blows across the lake and pushes it into New York.
And it says, okay, so you spoke with this individual prior to D.A. Willis taking office. He said, I did.
I forget what they call it. Sheening or something like that.
Before she took office.
No.
Okay. This is a letter. Let's see that on this one as well so we can see it better.
Benny Thompson.
Ms. Willis to, I believe, Congressman Benny Thompson, who's chairman of the Jan 6 committee. Have you
Illegal Jan 6
seen this letter before?
But Fanny's pumping him for information. Benny.
It says 2021 on it.
I'm sorry. Is that what I said, or I forget what I said?
Well, no, I'm just
Okay.
going through the process in my mind. It says 2021 on it. I can't remember. I'm searching for you.
Sure.
I can't pull it.
Just read it.
So this says, please accept this letter as an official request from me to access to records that may be relevant to our criminal investigation. Those records include, but are not limited to, the recordings and transcripts of witnesses, interviews and depositions, electronic and print records of communications, and records of travel. Do you recall there being conversations within the office relative to asking the Gen 6 committee for help relative to any of the things that I just read off that list there?
I don't recall.
Brain's fried.
And that, you're right, that was December of 2021. This here, I'll zoom in so we can see this better. This is an invoice from 5 months later for a team meeting. It's like a colon there. Conf with Jan 6, researching legal issues to prep, enter what I assume is a shorthand there for interview. Do you remember a conference call that you had with the January 6th committee?
It may be a bitch to get off of the turnpike up here. I probably should have taken the side road.
No, certainly I'm not.
Now that I see it backing up the way it is.
I'm just saying I don't remember the call.
A lot of these trucks are, look at this idiot going to just cut in front of me.
Sure. I said, certainly I'm not implying that it didn't happen.
Fuck you doing, dude?
I don't remember the call.
Sure. Do you remember any calls that you had with the Gen 6 committee?
I don't.
Do you remember any meetings you had with the Gen 6 committee?
I don't.
What was the role of the Gen 6 committee, as you understand it?
I don't recall.
I'm asking you to recall. I'm asking you what you believe the role of the committee to
be. You're asking me what was their role as it relates to
generally.
No,
do you remember them at all?
I'll refine the question as it refers to their existence.
Well, I didn't work with the January 6th committee. So
yes, you did. You built it.
Their role as defined by their
it says right here.
Organizers or staff.
Team meeting conference call with Jan 6 research, legal and prep.
So I don't want to sit and try and.
You spent 24 hours doing it there.
Charged with doing because I had nothing to do with it.
Okay.
It's on the screen there, dude. What are you talking about? It's right there. Team meeting, January 6th committee, 24 hours.
Scroll up on this one here.
You got paid $6,000 for that meeting. You can't remember a $6,000 meeting?
Down, it's just the actual camera.
Hammerhead.
Entry here from about 10 days later. I believe it says travel over here. Travel out of state, interview, and research. Do you recall?
No.
Specifically, what that travel was?
I have no clue.
That's
2022.
Yeah, it was a long time ago.
Not
4
really.
years. 4 years. It's not that long ago.
This guy.
I'm going to show you a Politico article here. Have you seen this article here before? It says Jan 6 committee helped guide early days of Georgia Trump probe.
I've not.
Wow, look at this shit blowing. Oh, my goodness.
In the spring of 2022, the committee staff helped Fulton County prosecutors prepare for interviews with key witnesses. Do you recall either you or your staff working with the Jan 6 committee to prepare for interviews with key witnesses?
No.
Okay.
You billed thousands of dollars for it there, Nathan.
In the body of the article, it says the committee staff quietly met with lawyers and agents working for Fulton County District Attorney Fonnie Willis in mid-April of 2022, just as she prepared to convene a special grand jury investigation. In the previously unreported meeting, the Jan 6 committee aides let the district attorney's team review but not keep a limited set of evidence they had gathered. Do you recall a meeting with the committee where there was access given to evidence that you were able to view but not retain?
I do recall that.
Okay. Can you tell me about that meeting? Or do you recall where that meeting was?
That meeting was in Washington, D.C.
Okay, yeah. It's coming back to you there, Nathan, huh?
Do you recall if that was the meeting that is billed for here? Now that you're...
No.
Okay. Seems to be in the same time frame. That trip happened in April. So, obviously, it says spring of 2022 here. So, that was in Washington, D.C. Who went to D.C. with you on that trip?
I remember an investigator, but I don't recall specifically which investigator went. And I do recall that there were maybe 3 lawyers from the team, but I don't recall specifically who they were.
And that investigator would be from your team as well, one of the 5 to 10 people y'all worked with. So 3 lawyers, maybe 1 investigator.
Good. They did Joe.
Who did y'all meet with there? Do you remember?
Liz.
An attorney.
Liz Cheney.
Do you recall who the attorney was working for?
I do not recall her name.
You know it was a female.
Can we mute this for 1 second?
Yes, sir.
Don't say Liz Cheney. That's my legal advice to you.
No good. Okay.
So, just point of clarification.
Yes, sir.
Meeting with this lawyer, the young lady, she was not a member of that committee. This was an attorney.
And she was an attorney working for the committee?
I don't know who employed her.
Right.
But that's who we met with.
Right. Meeting random lawyers.
And had the conversations.
Was there anyone else besides this attorney and your staff that was at this meeting?
I don't remember anyone else.
Okay. So this lawyer, you said helped, essentially showed y'all evidence, excuse me, not help, but showed you guys evidence that had been gathered and did not allow you to retain that evidence. Is that correct?
That's correct.
Okay. Do you recall the evidence that she provided to you?
I don't.
Okay. His panel and Fulton County prosecutors. Does that help you remember any other staff level contacts that were not inclusive of that one meeting with the attorney?
No, sir.
Okay. In early April 2022, nearly 2 weeks before the panel, staff met with Willis's team, which does seem to then point to that entry that you did have on your billing as being the correct one for that meeting. Thompson told reporters he wasn't aware of how extensive those contacts were. On Wednesday, Thompson told Politico that he did not know about the in-person visit that spring. So, did you ever meet with Benny Thompson?
No.
Representative Benny Thompson?
I never met with him, but it would seem that it makes sense. If he's saying that he wasn't aware, then perhaps the young lady, the attorney that we were talking about, wasn't even affiliated with Mr. Thompson. I can't put that together for you.
Why are you meeting with random people?
Yeah, I think he said what he wasn't. He says he wasn't aware of how extensive those contacts were, but certainly he says he previously described staff level contacts, so he was aware. I think what he's saying he's not aware of is how extensive those contacts were. And I'm just trying to get a better understanding of how extensive those contacts were. Goes on to say, in the meeting, members of Wilson's team interviewed some of the committee's evidence on Georgia-specific matters, including Trump's efforts to pressure local officials and the fake electors' actions in the state. Do you remember viewing any such evidence with that attorney when you were in D.C.?
No, I do not recall.
No.
Okay.
No. Evidence? No. From the committee?
It says here, committee staff had more calls with the prosecutors over the following months, including discussions of their conversations with witnesses with whom the prosecutors were planning to interview. The calls helped prosecutors prepare for those interviews. One witness they discussed was Pat Cipollone, Trump's final White House counsel, who spoke with the committee investigators just days before the meeting with Willis's team. Do you remember any calls that helped your staff prepare for testimony from Pat Cipollone?
I do not. I'm not certain who the author of this article is, but I'm certain that they would have no firsthand knowledge of what the content of any phone calls were or conversations.
That's why we're asking you there, man.
Witnesses were. We prepared as a team. We prepared ourselves for interviewing those witnesses, utilizing the evidence that was collected and gathered by our investigators and ourselves, our team itself.
Do you recall if your committee deposed Pat Cipollone?
That means yes. He's processing something.
I'm struggling to. I mean, I recall there being some discussion around it. I don't specifically recall whether we interviewed Cipollone or not.
Did you sit in on most of the interviews or depositions?
All
of them. So if there was an interview or deposition with the president's White House counsel, that you would have sat in on that?
I would have.
Do you recall that, if that happened or not?
I don't.
Okay.
No. Just the White House lawyer. You don't remember that.
We'll go to our next slide here. Unmute you. Or sorry, you're muted.
Yeah, great comment from one old guy.
Okay.
Do you know what day it is? Do you know who the president is? Do you know what your name
White
is?
House stationery. This letter,
This old guy.
Mr. Wade, was part of an open records request that was just fulfilled about 2 or 3 weeks ago. American First Legal and Just the News had filed an open records request that was fought in court. I think that before there was a final ruling on that, there was 8,000 pages that were released. Some of those have been made public. This is one of those, just so you know the origin of this. So this is relatively new to the public record, but was voluntarily released by the district attorney's office. Have you seen this letter before from the White House to Mr. Donald Wakeford?
I'm not recalling. I won't say that I've never seen it, but it's stated in 2022.
Large debris is hitting me.
Mr. Wakeford, I'm certain I was made aware of it.
We haven't talked to Mr. Wakeford. That's the first time I've seen his name. This would appear that was he on staff?
You received my payment.
Or was he a contractor?
He was on staff.
He's a staff member. Was he part of your team?
Yes.
Okay. Was he one of the 3 attorneys that traveled with you to Washington, D.C. to meet with the attorney?
I don't recall. I do know that he did do some travel. I don't recall specifically which trips Mr. Wakeford.
Okay. This is a 2-page letter. I'll show you the ending of the second page, because what's at least somewhat significant of this, I think, as it relates to the investigation that you were a part of, is where President Biden waived the executive privilege with respect to testimony of former Trump administration officials before the special purpose grand jury, which would be your grand jury, or the DA's grand jury that you were helping lead.
And them signs are twisted in the wind.
Related to the subjects in the prior paragraphs. Does this help you recall at least the overall purpose of this letter? Do you recall executive privilege being waived by the Biden White House?
Well, based upon the letter you put up there, I mean, obviously it's about executive privilege, so yes.
What? Do you recall that executive privilege was waived as it related to the White House? President Trump's executive privilege was waived as it related to your investigation?
Yes, sir. The letter said.
Okay. What witnesses did that give you access to that you would not have otherwise had access to?
I don't recall. Yeah, that's way too complicated for
Would Cipollone be one of those?
Yeah, I don't recall which specific witnesses there were.
BJ Pack could be the U.S. attorney that they come.
Would it be you understand that BJ Pack would be someone whose privilege was waived here?
I do recall interviewing BJ Pack.
Okay.
Wow, memory.
Who else from the Trump administration do you recall interviewing?
I don't recall. Anyone? Name a name.
Yeah, I'm drawing a blank. If you gave me a list of witnesses, I could probably identify.
Mark Meadows.
Mark Meadows.
You interviewed Mark Meadows.
Yes.
Cipollone. You already said yes to Cipollone.
No.
Well, we're getting pretty close into the substance of the investigation. So I just want to make sure that we're not.
Yeah, I mean, one of these is in a news article.
We're asking about newspaper reports, public documents, that's fine. But if we're asking about what went on in certain conversations.
Do you recall the event of privilege being waived, something that you were waiting on to be able to proceed with interviews of people that you wanted to talk to?
Pursuant to this letter?
Pursuant to, you would not have had access to them because privilege would prevent you from interviewing them. This letter comes and now you have access to them.
Yes.
Okay. Would you describe this as a significant moment in the prosecution that gave you access to those individuals that would help you build your case?
I don't think one piece of evidence is any more significant than any other.
Well, that's dumb.
The evidence is what it is, and I wouldn't weigh any piece heavier than
that's
any
pretty
other
dumb.
piece, so
yeah, like the murder weapon is pretty important.
Significant or not significant. It's just a piece of evidence.
It's my understanding that the purpose of executive privilege essentially is to prevent this kind of thing from happening, where the president would have the ability to adjudicate his duties and would be able to go to his counsel similar to the way that we're all going to our counsel with privacy and be able to get an honest conversation. It would appear to me, at least, that the waiving of that by President Biden was significant. Do you recall, as it relates to Mr. Wakeford, talking to him about asking for privilege to be waived from the White House?
I don't recall.
Do you know if Mr. Wakeford asked for privilege to be waived from the White House?
You get the processes to proceed on witnesses, so I object on that basis. It gets into the deliberative process on whether.
Thank you, Governor. We got the objection.
Yes. I'm entitled to make the record. You don't have to tell me.
I think you've made the objection.
Oh, I'm entitled to make the record and make it fully.
Let's hear the testimony.
Yeah. Did you say that?
I said, let's hear your testimony.
Well, I present.
Governor, your objection is on
Objection is that it gets to processes and procedures of how the investigation went on. The question is, did Mr. Wakeford ask for and encourage the waiving of the privilege? That gets into a process or procedure of how the investigation is undertaken. You can ask him whether, and you got the letter, you can ask him, did he request it?
So, Mr. Wade, do you understand the question that I just asked?
What's the question?
The question is, did you discuss with Mr. Wakeford, or did you request from Mr. Wakeford to seek the waiver of privilege?
I don't recall. I have to.
Okay. This document here was another email to Mr. Wakeford that was part of that open records request that I referenced earlier, same place we got the White House letter that I just showed you. This is an email from Mr. Wakeford dated March 14th, 2022 to a Miss Lori Baranek, I believe, perhaps is the pronunciation. Does that name ring a bell to you? Lori Baranek?
It does.
Who's Miss Baranek?
She's the person that this letter went to.
What does she do for a living?
I'm not sure.
It's like assistant U.S. attorney.
USA.
An assistant U.S. attorney.
Okay.
Nice.
And this is Mr. Wakeford asking the assistant U.S. attorney. I wanted to reach out to you, see if it might be possible for a couple of us from FCDAO to come up the road and sit down with you for a few minutes later this week, possibly Thursday. We anticipate we might have to make a few more TUI requests, and I thought it would be beneficial to have a conversation about that process. Just let me know if there's something we might be able to work out. Either way, we'll see you on Monday at 1 Atlantic Center. The number below is my direct line. We've heard testimony before about the TUI requests that y'all are working on. Can you just refresh the committee's memory of what a TUI request is?
Just getting permission to talk to people.
Okay. And do you recall if you traveled to this meeting with Ms. Baranek?
I don't recall specifically being there, but I can say that if it was a meeting, I was there.
Okay. Do you know what the meeting is here that's referenced Monday at 1 Atlantic Center?
Process and deliberation of the investigation. But do you know what the meeting was about?
I asked if you remember. Do you remember attending the meeting? I'll clarify that. Do you remember attending the meeting in March at 1 Atlantic Center?
Again, I don't recall specifically attending the meeting, but if the meeting occurred, I was there.
Okay. So she's with the Department of Justice. This is another email from the Department of Justice to Mr. Wakeford. I actually don't see a date on this one here, but the headline here, the heading on the second one does show us that page. Shows the date of May 1st, 2022. It's just a couple months after the last one. This one here is from Mr. J.
Yeah, we read
Macklin.
this one before.
Do you know who Mr. Macklin is?
I do not.
Okay.
Of course you know. We're not denying your request, but we're going to continue to work with you.
And it says, well, we write in response to your April 19, 2022 letter, Civil Chief Lori Baranek requesting the DOJ's authorization to interview 5 individuals in conjunction. And it says, it goes on to list former Attorney General William Barr, Acting Attorney General.
I'll be right back.
Rosen,
What's the code here again?
Deputy Attorney General Donahue, former Assistant Attorney General Stephen Engel, and Inspector General Michael Horowitz. Were those all individuals that you interviewed?
I don't recall.
Do you recall if you interviewed Bill Barr?
I don't recall.
You don't recall Bill?
Is there any individual on that list that you recall interviewing?
I guess what I'm communicating to you is we could have interviewed all, none, or some of them.
And I don't know anything.
I have no independent recollection of any of these people.
Okay.
Oh my gosh. You don't remember Bill Barr, of all people?
This is an email from Michael Hill to a redacted individual here, but appears to be Miss Alexis Hunter. Who's Michael
I'll be right
Hill?
back.
He was a former investigator for Fulton County District Attorney's Office.
Working as part of the team that you were leading?
Yes, sir.
Okay. Was he the investigator that traveled to D.C.?
I don't recall if it was this investigator or some other.
So he identifies himself as senior investigative officer. Our office is currently engaged in ongoing investigation. As we discussed, my team and I would like a brief audience with Congressman Thompson related to the aforementioned subject matter. Please forward this communication to Mr. Thompson. Email response comes from Mr. Tim Heapy, Investigator Hill. He identifies himself as Chief Investigative Counsel for the House of Representatives Select Committee to investigate Jan 6. We call that the Jan 6 Committee. I understand you reached out today. Some or all members of the Select Committee seeking information about our interaction with two particular witnesses. Do you know who Mr. Tim Heapy is?
As I recall, Mr. Heaphy was one of the lawyers that was in communication with us.
One of the lawyers for the Jan 6 Committee?
Again, I don't know that he would have been characterized as such, but Mr. Heaphy and this young lady were associates of some sort.
Okay. Did you ever meet with Mr. Heaphy?
Yes.
Okay.
I just want to say something about the process. You don't meet with a committee when you go to DC. When he's referring to the select committee, there's independent lawyers that they bring in, various people. You don't know, just because it's on somebody's signature line, you don't know what role they're actually playing with it. So there's layers to these things, and there's nobody that just represents the committee.
Okay, he can explain that.
That's a job in itself. These are independent folks that.
All right, so friends, I got to wrap. We have an ultrasound for my beautiful wife. She is going to get scanned and all the things. So we got to head out the door. I didn't realize what time it was. But we'll pause here. Apologies for that, but let me drop the link in the chats in case you want to go and check it out. If you want to listen to him continue to say, I don't recall, I don't recall, I don't recall, I don't recall. Dropping that one on YouTube, dropping that over on Locals, and we'll, of course, we'll debrief that. Members, we'll come back tomorrow. We'll get into it. We had some great donos to check in on. And then your boys got to get out the door. For some reason, I thought the times were a little different, but they're not. But what we've got is some amazing donos. So thank you for being here. Sorry for the abrupt cut on that, but I'm sure you're falling asleep anyways because Nathan can't remember a damn thing. But it's been a beautiful stream. Let's say what's up to these donos, and then your boy is racing out the door here. And of course, we had Pauline. I'm just getting started, baby. 98 and young. 98 and young. Amazing. Thank you for that, Muffin Rando. Sev Russ, what's going on? Hey, we got this. Says, first, sorry for the bad joke yesterday. I checked that. I looked that one up, and that was the trans model joke, which, you know, I don't know if it's a bad joke. It's just a spicy joke. No apology necessary. More importantly, safe travels to DC. Sev Russ, you're a membo. Hopefully we can say goodbye in the morning. We'll come back, and we'll wrap it up here. And it'll be a great little short Saturday stream just to say our proper goodbyes. Severus, thanks for bringing in some new friends. Hopefully you can join us in the morning. What's it to ya? 3000. Evan Wagler, what's up? Why though is here. Deborah Skinnett and another year older, and for being here. We've got Rhino Poop. Hey, yeah, what's up, Rhino Poop? It has been a long time. Says long time. Today I'm compelled to state my admiration for you. What? I'm an old Northeast patriot with 400-year-old roots. Oh, wow. Mayflower compact on the dad's side. Amazing. On mom's side, a grateful second-gen legal immigrant. My nom de plume, comic relief and reminder to clean up poop like Cornyn. No one else dissects and explains the complex like you, serious with a common sense of humor. Man, thank you for that. I wish you, your lovely bride, and baby G the best fortunes and happiness with the move and adventure. Man, thank you so much for that, Rhino Poop. It has been a while. I haven't seen you in the chat. It's great to have you here. Thank you for the very nice dono and the well wishes. And man, I love that. That history is just awesome. Just awesome. So thank you for that. Yeah, we're going to go. We got a doctor's appointment basically all afternoon. I think we got 2 back-to-back, like an hour and an hour. And so that's what we're doing this afternoon. And then we're packing up. We've got some moving pods coming tomorrow. So we'll have a quick stream in the morning. We'll test out the mobile rig together and say our goodbyes. And then we'll call it a day in this location. So this is it, man. Thank you for that, Rhino Poop. Hey, Renee Sargent, have a fun move. Moving is so fun. I love it. Yeah, we're having a great time. Packing boxes. Oh, gosh. It's a lot of fun. Renee, thank you. Jesser Bob, we need to see the quantity of Roland Paper Company paper that was ordered for the election. If Georgia only ordered 1.5 million sheets of ballot paper and 2 million ballots were received, then there is more proof they faked 1/2 million ballots. We also need a copy of all the records from Roland to prove that they are not ordering extra and stockpiling for the next election too. From Jesser Bob. It's a good idea. Where'd the paper come from? George Garbanzo. Hello, my friend. Been a while. What's up, George? It has been a while. It's good to see you. Pookie's Mob. We're wearing the Nathan hot dog hat. And this old guy says, quit starting your questions, but do you recall?
As soon as I left, the
just
fucking
sets the
phone
stage
rang,
for
didn't
no-
it?
Oh, just asked him if he enjoyed the trips and the cruises. Hey,
Hi, this is Fragile Pat. On a recorded line, we had called to schedule your delivery from AFES. I'd like to confirm your delivery address. Is that okay?
Yes. Look at that thing.
You need to carry your order up any steps or stairs?
No.
Are there low-hanging branches, narrow roads, or other features that might prevent a 13-foot tall truck from reaching the location for your order?
No.
Is this a business delivery?
No.
Let me get your answer saved one moment. Let me get the first available dates for delivery. The soonest available delivery date is Monday, March 23rd, 2026. Would that work for you?
Yes.
So to confirm, you would like me to schedule your delivery for Monday, March 23rd, 2026?
Yes.
Let me get that scheduled for you. Your order has been scheduled for Monday, March 23rd, 2026. A confirmation message and tracking number have been sent to you via text and email. Would you like me to provide your tracking number for this order?
No. In the email, yes.
Got it. You'll get the tracking number in your email.
Yes.
Is there anything else I can help you with today?
No. No.
Thanks for your time today. Take care.
But all right, I'm back. Yeah,
Welcome back. How can I assist you further with your delivery
Oh,
today?
sorry, I'm done. Thought I hung up. What up, Eggsy? Yeah, that's I think that tree saved me. I don't know who to call about this. Let me call somebody real quick.
Tama Drummer, what's up? 28 months as a member. Thank you, Tama, for being here. Says, and this is what we...
It looks like I'm gonna have to end the stream just because I'm gonna have to go inside and use this phone for stuff. Let me run across the street here.
The same thing happened.
Great, it's out of nowhere. Had a stroke. Super hard, obviously, for the whole family, but my dad had life insurance. This is why I have life insurance for my family, for my wife, and 4 kids. And the best place to get life insurance is inDOCtriNATIONlive. Because
Yeah.
you can do it in 10 minutes.
Wind's blowing so hard that the water levels have dropped significantly on this side of the lake.
Family is protected. Ethos.
It's weird how it does that.
Ethos.com/Slater.
He's Donald Trump's #1 enemy in Congress, Chicago politician Dick Durbin. Now, Durbin has a new scheme. He's doing the work to benefit corporate megastores. Durbin's bill will cut corners on your credit card security, putting your personal data at risk. Big chain retailers and warehouse stores want to inflate their profits. And liberal dictators...
All right, brother, I will be back. I think I'll fire it up whenever I leave here, okay? Peace.
Megastores and Dick Durbin.